Well, many Americans are concerned that the federal government in the recent health care legislation that was passed, that Congress has imposed an individual mandate on health coverage and imposed a penalty, a financial penalty, if you don't purchase government-approved health insurance. To my knowledge, that would represent an unprecedented reach of Congress's authority to legislate under the Interstate Commerce Clause, under the guise of regulating interstate commerce. But again, the 10th Amendment, which I think most people sort of popularly view as an expression of our federalist system, and the fact that the states and individuals retain power that's not been delegated to the federal government, has largely, in my opinion, been rendered a dead letter by Supreme Court decisions. Now, I grant you that the Rehnquist Court, the Lopez case, and others did begin to work a little bit around the edges, but if Congress can force people to who are sitting on their couch at home to purchase a product and penalize them if they don't purchase the government-approved product, it seems to me there is no limit to the federal government's authority, and we've come a long, long way from what our founders intended.
Well, I think the current state of the law is to grant broad deference to Congress in this area, to assume that Congress knows what's necessary in terms of the regulation of the country's economy, but to have some limits, and the limits are the ones that were set forth in the cases that you mentioned, the Lopez case and the Morrison case, which are where the activity that's being regulated is not itself economic in nature, and is activity that's traditionally been regulated by the states. But to the extent that Congress regulates the channels of commerce, the instrumentalities of commerce, and also to the extent that Congress is regulating things that substantially affect interstate commerce, there the court has given Congress broad discretion.
I was pleased to hear you say that once decided by the Supreme Court, even by a 5-4 margin, that cases like Heller, McDonald, Citizens United are the law of the land and entitled to deference by succeeding courts, even if you may disagree with the outcome. Did I state that correctly?
Yes, surely. The entire idea of precedent is that you can think a decision is wrong. You can have decided it's differently if you had been on the court when that decision was made, and nonetheless, you are bound by that decision. That's the if the doctrine of precedent enabled you to overturn every decision that you thought was wrong, it wouldn't be much of a doctrine.
Is it within the Constitution for me to write a bill, having been duly elected by the people of Oklahoma, to say, and get it signed by the President, that you have to eat 3 fruits and 3 vegetables every day?
As I talked about with Senator Cornyn, the Commerce Clause has been interpreted broadly, that the Congress can't regulate non-economic activities, especially to the extent that those activities have traditionally been regulated by the states. And I think that that would be the question that the court would ask with respect to any case of this kind.
So the fact is that we have this expansive clause, and we have to have some limit on it. And if the courts aren't going to limit it within the original intent, instead of continuing to rely on precedent of this vast expansion of it, the only hope is that we have to throw out most of the Congress. But the point is their original intent is that you wouldn't ignore their original intent. And what we find ourselves today on the Commerce Clause is that through a period of precedent-setting decisions, we have allowed the federal government to become something that it was never entitled to become. And with that, a diminishment of the liberties of the people of this country, both financially and in terms of their own liberty.
Well, Senator Coburn, I guess a few points. The first is I think that there are limits on the Commerce Clause of the ones I suggested, which are the ones that were articulated by the court in Morrison and in Lopez. which are primarily about non-economic activity and Congress not being able to regulate non-economic activity. I guess the second point I would make is I do think that very early in our history, and especially I would look to Gibbons v. Ogden, where Chief Justice Marshall did in the first case about these issues, essentially read that clause broadly and provide real deference to legislatures and provide real deference to Congress about the scope of that clause. Not that the clause doesn't have any limits, but that deference should be provided to Congress with respect to matters affecting interstate commerce. And I guess the third point is just to say that I think the reason for that is that $1.6 trillion deficit may be an enormous problem. It may be an enormous problem, but I don't think it's a problem for courts to solve. I think it's a problem for the political process to solve.
You missed my whole point. We're here because the courts didn't do their job in limiting our ability to go outside of original intent on what the Commerce Clause was supposed to be. Sure, you can't solve the problem now, but you helped create it as a court because you allowed something other than what our original founders thought was a legitimate role for the federal government.